The topic for all four of us on the panel was, what's the effect of originalism on current Supreme Court doctrine on the First Amendment? Freedom of speech for the founding period was not just political. It was a natural law good. It was an essential element of what a flourishing life would be, and hence, for people whose government was formed on the consent of the people, the government had to understand that this fundamental good was solid and rock bottom. The modern Supreme Court has more or less adopted that attitude. Namely, when it develops doctrine and it says we have to allow content to have pride of place, no matter what the content is. Government can restrict how it's spoken, where it's spoken. Government can do some licensing, but on the whole, the nature of what is being spoken is up to the person and the listener to determine. That's basically what I think the founding generation said, and we have, I think, significant evidence of practice and of these kinds of documents that show it. Justice Scalia was not sympathetic to the originalism that I espoused, which is you look at authoritative statements by the founders in other contexts. He wanted something closer to a legal rule. He was much more of a legal positivist in that sense. And he would not have been sympathetic with this natural law view of freedom of speech as being an essential good to the human person, informing what the First Amendment means. Professor McConnell spent a lot of time discussing the difficulties in modern Supreme Court doctrine, attempting to decide what kind of content is protected and what kind of content even the framers would not have thought was protected. And the Supreme Court has not laid down very consistent rules as to how to draw that line. And he was very careful about that and very analytical about that. That remains a current problem for the Supreme Court to solve. Namely, although speech in general is to be protected, there are certain exceptions. How you define those exceptions is still a difficult issue.